Hello.
Welcome to the Business of Being a Board Game Artist panel. I'm going to introduce some people, and then we will start talking, and then have some Q&A. So that's what we got. So we're going to go down. I'm Paul Bender. I'm the CEO and manager of Greater Than Games. I'm just here to introduce people and answer minor business process questions and things as people have them. But going down, we have Nolan Nasser, who is an artist who works as an independent contractor. He works for a number of different gaming companies, including Greater Than Games. We've got Jennifer Clausen, who is the Greater Than Games creative director. So she's the main person at Greater Than Games, one of several people, but the main person who deals with contracting with and managing independent contractor artists. And so she's got some perspective about that stuff. And then we have Jennifer Beasley, who is one of Greater Than Games' attorneys, and she's attorney at the law firm of Jenkins and Kling in St. Louis, and she does contract law and a bunch of other kind of things like that. So she can talk about a bunch of those kind of things. And then finally, James Daly is a intellectual property law attorney that we use at Greater Than Games as well, and he's also the author of the blog Law in the Multiverse and the book The Law of Superheroes. So anyway, we will get going. So Nolan, I think we're going to start out with you talking about just marketing to board game companies and stuff like that.
So
how do you run your business?
Right.
As an independent contractor and stuff like that? What do you do?
Right. So I started out doing a lot of things. There's a lot of things that go into marketing as an artist. You need a portfolio website or something. You need something to show people, right? So as an artist, to distill it down even further, as an artist, there's two things I do. I draw pictures and I show them to people. And that's 50-50 what my job is, right? And so a lot of what I do is the marketing aspect, and that is I have portfolio websites, I have social media, and I'm constantly managing all those things. If I'm not drawing or painting, it's managing social media. And then, having an online presence is important, but only so much as to have a landing page or something to show people, right? At first, at least. There's a lot of different ways to do this, obviously. But having an online presence, having that social media, having that landing page that has your artwork on it and stuff like that is really important to show people, because the other, I think one of the most important parts is going to conventions and meeting people face to face and networking in order to market yourself. Most of the work that I've gotten has been through networking, has been through word of mouth, has been through other people possibly mentioning my name to somebody, or me going up to them face to face and talking to them. That is honestly how I get most of my work now. At first, it was a lot of just going to conventions and shaking hands with people and introducing myself and just shoving my artwork in front of people's faces, and that was the most important thing I could possibly do. That's you.
So now, so Nolan runs his business, right? Is being an independent contractor artist, and so that's what he does, and that's how he gets in contact with us. But then, when he's getting in contact with the company, he's talking to people like me and people like Jen and other people but we have different kind of things that we want. So for me, when I'm interacting with an artist, I want someone that can draw good pictures, yes, whatever. But there's various people that work for me, that work at our company, that goes and makes sure that their art looks good. I can look at art and be sure, that looks nice. I'm going to take a lot of things look nice that don't really look nice. That's not what matters, right, to me. That matters to other people. Janet matters, or Adam, that matters to him, that matters. And it matters to me that it matters to them. Because I want it to sell well, I want it to look good, but someone needs to tell me if something looks good. I can totally sort of tell. But what really, really matters to me is that there's an artist that Jen or Adam think makes really good stuff that looks good, but then is very, very responsive and easy to deal with as a business. So for me, I want an artist that is going to be okay with the fact that I'm going to send them a contract, is going to respond to emails promptly, is not going to frustrate whoever is managing them drawing stuff, is going to be able to stick to deadlines, and is going to be able to respond professionally and efficiently to things. And so that is one of the things that, in the case of Nolan, when we wound up working with Nolan, we were working with a ton of different artists at the time, and it's actually comparatively rare to find someone that not only is good at drawing things, but then, from my perspective, is a professional business person, right? Who will, sign a contract, stick to deadlines on the contract. If anything is going to be a problem or come up in the future, let us know well in advance. That there might be some deadlines that get dropped or things like that. Talk about that and negotiate about that in advance instead of kind of falling off of the face of the earth and things like that. So I know that's a common thing that other people in my perspective, from my the business manager perspective, run into dealing with artists. Yeah. Some way you can really distinguish yourself as being professional. So, but then, yeah.
Yeah, as far as where do we find artists, or do we put out calls for submissions, things like that, and Nolan kind of touched on this too. we go out and we look on DeviantArt and we look on Behance, and we're searching through all of those sites. But then conventions like this, we're walking Artist Alley with projects in mind, looking at the artists, talking face to face to the artists, and seeing and getting those initial meetings and interactions and feeling them out. Like, do they seem professional? Do we think we could have a good working relationship with them? And then we start breaking into, the next phase of actually talking about specific projects and contracts and emailing back and forth. And we also it's important, it's a small community, it's all about networking as well. So there are times where we've been looking for an artist and I've actually turned to Nolan and been like, you've done really well for us and you know what style we're looking for this game. Do you know anybody? Or we'll talk to other businesses and, about, I worked with that person was really good, they were really responsive, things like that. So getting your name out there and really presenting yourself well from the beginning is extremely important.
So then moving on from that, we've mentioned a few times getting contracts and working and this kind of business stuff and how does that work. And so now I'm going to turn it over to the attorneys to talk about it a little bit.
Okay.
About how the contracting process works. Because for us as a company, by the way, it's very important that we have a contract. And for you as artists, it's also super important. And if a company doesn't just have a contract or have a standard contracting process or is weirded out by getting you a contract for your art, that's a huge red flag. You might not want to work for them.
Okay, so quick disclaimer, since this is the attorneys section. We're attorneys, but we're not your attorneys. We can give you general advice, especially once we get to the Q&A, but we can't give you specific advice about your specific situation because we're not your attorneys and this is a public forum, so there's no attorney-client privilege or anything like that. Like Paul said, most sophisticated board game companies are going to have their own form, and you should probably expect to use that. There's a lot of reasons from the company perspective why they're going to have their own form. The first is just for consistency. If you have multiple games and multiple artists on multiple games, it becomes very hard to track if you were using a whole bunch of different forms. There's a certain way that the company's forms read, and it's just easier if they know that everything's in order. Because when the company makes the product, they might later, and they don't necessarily know at the time of contracting, all of the future uses of that product and of the artwork. It's probably designed for a board game, but then they might license that or sell the rights to go and make a foreign language version of the board game or an electronic version of the board game. So you can probably expect to use the company's form. The first thing is, what can you expect to probably give up as an artist? And we're talking about the most common situations in a sophisticated board game company, of which I consider Greater Than Games. Anyone at that level, I would expect this. First is copyright ownership of the work. The board game company is going to want this. You're probably making six pieces of art for a board game. They have other artists making 6 pieces of art. The company wants to own the board game. It's important for the company if they ever sell their business, if they later license or sell that particular asset down the road. There's going to be a section in the contract that is probably a page and a half long that covers ownership. Because you're an independent contractor, it's a little bit trickier than if you're an employee. So you're going to see words like work made for hire. You're going to see an assignment provision. You're probably going to see something called a power of attorney that gives the company the right to sign a bill of sale or assignment if you, for some reason in the future, refuse to do so. In rare cases, you might be able to license your work rather than have the company own it, but it would have to be exceptional. In these cases, it would be an artist who has a very particular talent that is doing a very particular thing, and you have a disproportionate amount of bargaining power. In general, the company is going to want to retain ownership from the time your work is created. That doesn't mean, though, that you can't ever use it in the future. What most companies, including Greater Than Games, will do will give you a license back. So they own it, and then they license the artwork that you create for the game or whatever product back to you. The license, you can ask for it'll be for particular things. Like, one, use it in a portfolio. Most companies are not going to have a problem with this because you're using it commercially, but you're not generally selling it. 2, you could sell limited prints or something. There might be restrictions on this, though. Keep in mind, from the business decision of the company, let's say you do the art for a playmat. They might have some restrictions on the license back to you for selling it as a playmat if you're going to be, directly competing with the same product the company is producing. The other important thing to remember when you're going to exercise on the license and you're going to, include it in a portfolio or sell prints of it is confidentiality provisions in the contract. Most of these contracts will have confidential information. it'll be fairly broad because it's going to be the company's standard form. They're not going to do a specific form for only the information they expect to give to you. It'll be anything. So they might be telling you deadlines and release deadlines. They might be telling you names of the product, anything that's basically not released to the public yet. So let's say you do a character picture, and that character is designed to be a Kickstarter reward, and that's actually a locked reward, so they're keeping that particular character's existence secret. You wouldn't want to include your artwork for that character in your portfolio until the company releases it first. That's one thing to keep in mind when working on the license. So we've talked about what you can expect to give up. The other thing is, what do you want in return in these contracts? And the first thing is money or compensation. In general, for the artists, for what you're doing, if it's a set number of pieces of art, something like that, you're going to want probably a set dollar amount. That's certainly the safest, most easily ascertainable, less risk to the artist. You can sometimes get into situations, especially with smaller companies, where they're going to give you a percentage. There's a few things to be careful of and risks that you should be aware of if you're talking to the company about you're going to take a percentage of their profits or revenue. One thing is the difference between percentage of net proceeds versus gross proceeds. So gross means all of the revenue the company derives from the product or whatever you're getting the percentage out of. Gross can only go down to 0. Net proceeds means the gross minus all of the company's costs associated with that product. So that could be 0. It can also be a negative number. The other risk to be aware of when you're talking about accepting a percentage rather than an actual concrete dollar amount is that means that you getting paid is implicitly dependent on the company actually producing the game. If the company decides later on not to produce the game, and for a lot of these companies, you'll be making art before they've even necessarily run a Kickstarter. So if the Kickstarter fails, the company decides to not produce the game, you wouldn't get paid if you're just getting a percentage because they're both their gross and their net are 0 at that point. The third thing to think about is from a business perspective as the artist is if you are accepting a percentage, this is a greater risk to you. So let's say that you would normally charge $500 for the work that you're doing for the company, and they're offering you instead 25%. And one thing that's reasonable to ask them is what do they expect? If you are talking about a percentage, is what they expect to make, what their past sales have been for other products. They might not give you this information, but you need to at least know sort of what you're expecting the total to be. But let's say it's 25% and they expect to make $2,000. Well, that's only your $500. You're not really being compensated for the risk, because if you were to repeat this transaction over and over, there's the risk you have to take into account that they won't produce it, that it won't make the revenue they had. So you might want to set a higher number than you would otherwise for when you're getting a fixed dollar amount. The next thing that's very important about your compensation is you want it at a definite ascertainable time. There are issues with contingencies. You, in general, don't want it contingent on whether or not they produce a game. That's entirely out of your control. It's not in your favor. Most reputable larger companies won't do that. It's best to have sort of the amount dispersed. You can have like 2 or 3 disbursements, 1 or 2 payments either at contracting. That might be rare, especially if you don't have a reputation in the industry, so the company doesn't have assurances that you'll deliver. But maybe when you deliver drafts, a lot of the contracts will provide for drafts before you deliver a final product, so everyone can make sure we're all on the same page regarding deliverables. Have some amount due at draft and then some amount due at final completion. It doesn't have to be a date, like definitely I will get so many dollars on January 15th, but it should be something like 10 days after I deliver drafts, then I will get paid X percent of the total amount, which is like $500 that I'm getting paid for this contract. There is a new trend in law that you might have heard about, the sort of the freelance isn't free laws. Those are very new. In general, they're good. They protect freelance artists, but New York City, the city, not the state, May of 2017, it's the first law in the country, so it's fairly rare still, went into effect. That particular law mandates that freelancers be paid in full for work that's $800 or more, either by the date set in the contract or within 30 days of handing over completed work. And then it provides for a complaint process that goes through the city that's easier for the individual to handle, and it's less expensive than filing litigation. And while that's all well and good, and I think it's a positive step for freelance artists, it's not going to be a substitute for a well-drafted contract. Because if your payment is contingent on them publishing the game, then the payment isn't late and you wouldn't really have a recourse under the law. Also, right now, it's only in New York City. It hasn't been enacted anywhere else. So even as you see things that pop up, and I expect there's more freelance artists and freelancer nonprofit organizations that are trying to get these laws promulgated in more states. So I think you'll start hearing about it more if you haven't already. But keep in mind, it's not going to be really a substitute for a well-drafted contract that you can understand. The next thing that we want to talk, what you want to see in the contract and what you might want to think about negotiating is credit. This is probably going to be negotiated directly with the company, and it's going to depend on your level of involvement. Sort of standard is you'll get credit either online or in the instruction book, not necessarily associated with your particular piece of artwork, especially depending on what the artwork is for and what the company has already said they'll put other people's names on. Aesthetically, it might not be possible. But one thing to know is whether or not you are going to get credit, and to look for that to be specified in the contract itself. The third thing that you're going to want to see and pay attention to in the contract is your list of deliverables and deadlines. The deliverables, what you have to do, it's not going to spell out every single particular thing. Even our contract, which it's industry standard, but a little on the longer side. It's less than 10 pages. So it is not going to specify like, I want this character with this particular aesthetic features. It's going to give you sort of a broad template, but it should have a number and just general rough guidelines for what they're expecting.
Like this many yards, roughly this kind of them. We usually put in like this DPI or whatever. Mm-hmm. Yeah, we'll put in stuff like that.
So there'll be some specifics. Not everything's going to be spelled out, but you want to know the number and when you have to have the art ready by. Be realistic in your expectations, because the number one thing that is going to prevent you from getting future business from this company, and maybe not number one, but certainly a major factor for getting future business from this company and having this company refer you out, is going to be if you can't meet that deadline. If you tell them now, they can work with that. For example, let's say you're making 10 total art and they want it in a timeline that you just can't meet. Ask them, though, if you can provide 5 pieces of art by an earlier deadline and 5 pieces later. Because it could be they need for a Kickstarter campaign the art, but they can make it work with 5 pieces instead of the 10.
Yeah, that's definitely a case where, like, if you have really good feedback and communication about what your deadlines need to be, and be like, well, I work in this kind of medium, so it takes this kind of time, and I've got these other contracts, but I can definitely do it and hit this then and this other time. That's awesome, and that's like a really good sign for us. So we'd rather hear that as opposed to be like, sure, I'll do 10 arts in 2 weeks, and then you're like, nah, it's like a month later and we haven't heard from you, and then you feel sad and don't want to respond to our emails because you feel guilty. That's bad. So don't get in that situation.
Yeah, I mean, the number one thing you can do is, if you want to be in the business of being a board game artist and you're dealing with companies, is to be a business person yourself. So the earlier you can note something, especially at the contracting process, be realistic about what your other projects are, what you anticipate coming up in the future, and what your deadlines are, because companies are much more willing to negotiate at this point about when you need stuff by. The things you should pay attention to in the contract. Yeah.
So one thing I wanted to mention before we move on to the next section is that when we talk about things like deadlines and the like, you may think, I don't want to specify all that. I want to be more free-flowing or whatever, but you don't want to feel hemmed in. But having those deadlines and having some relatively specific set of deliverables is very useful for you because it means that you have something that you can say, if necessary, in court. If they fail to pay you, hey, I did what the contract said. I kept up my end of the bargain. So these kinds of things are not just, it's just for the board game company so they can demand that you turn over that art. It's also useful for you so that you can more easily show that you fulfilled your side of the contract. And in general, when dealing with contracts, you want to, and any kind of business negotiation, you want to plan for success and you want to plan for failure. You want to make sure that the contract shows how things are going to go. If everything works and everyone's happy, you want to make sure that, I'm going to get paid the right amount of money and I'm going to get the credit I want, and that's great. But you also want to make sure that it is contemplated and is, fairly addresses how things are going to go if it doesn't work out. If you don't meet the deadline, or if they fail to pay you, or whatever, however it fails. So bear that in mind. You want to have both a plan for success and a plan for failure.
Okay, so the next section we're going to talk about is you're going to get a 10-page contract. What are sort of the most key important provisions that you should pay attention to? The first thing that's not in the contract itself is the reputation of the company. The contract, like I said, is only going to address so much. There's going to be blanks. So at some point, it's going to come down to how the company handles its business. And to the extent you know that they've had problems with paying contractors or other contractors have performed and not paid, then the contract is going to be more important for you to negotiate and really nail down what you're getting, when you're getting, why, just from a business risk perspective. Keep in mind, though, that in almost all of these contracts, the company can assign your contract to someone else. You can't assign it. It's a personal services contract. The company is hiring you based on your portfolio to personally draw this artwork, but all of these are going to be assignable by the company. They have to, because in the future they're probably going to license it, but also if they sold the company. So it's
like if Asmodee buys them, they got to be able to assign the contract to Asmodee, so don't get drugged for them.
Yeah, so Asmodee will produce the game. So unlikely in any particular contract that your contract will be assigned while you're still performing work, but it's possible. So just keep that in mind. We talked about, though, what do you have to do, when do you have to do it by, and compensation already. Those are all important terms to take a look at, make sure you know. And like James was saying, one of the important things on why you want everything specified out is because if the company assigns the contract, you could be dealing with an entirely new person on the other side. And you want to make sure that they will know from the contract exactly what you both sides were thinking when you entered into it. The next section to pay attention to is the termination provisions. In general, most of these are going to be terminable by the board game company or the game company. However, so there's two types of termination. One is for cause. For cause means you're in breach. You've not produced by the deadlines the products that you said you'd produce. And in general, most companies will try and work with you because it's a little bit faster for you if you've already started and can demonstrate some progress than if the company goes out and hires an entirely new person. So again, as long as you're responsive, you might be able to avoid them terminating for cause, even if you are in breach. I'm not saying that they would, but just from a business perspective, keep that in mind as one of the reasons not to bury your head in the sand. The other type of termination is without cause, which means you're not in breach, but there could be business decisions as to why the company has decided not to pursue this particular product. It could be the artwork is being done during the Kickstarter campaign. The Kickstarter campaign didn't fund, and based on interest, the company just thinks this product is not going to be successful or not successful at this time without significant retooling. Termination for cause, you can expect to see that in there, but to protect the artist, what you want to see is some amount of prior notice required. And what that is going to do is protect you. So let's say you're 2 days away from delivering final artwork. You don't want the contract to be terminated immediately and the company to be able to avoid paying you because of that. But if you have something like 20 days prior notice termination, you're 2 days away, you deliver the final artwork. Once you deliver it, the company, assuming it meets the terms of the contract, the company then has to pay you for it. So that prior notice can protect you for the work you've already done. You can submit that, sort of wind up the contract in an orderly fashion. The company, let's say you're just at the draft stage, you'd submit your drafts. You'd only get the money you're going to get through the draft stage, which is another reason to have a tiered payment structure. You get the money through the draft stage. You wouldn't get the money for delivering the final product, but you also haven't put the work into the final product yet. You're just through the draft stage. The other thing to pay attention to is the requirement that the work be original. It's often contained in the representation and warranty section, which for the most part are going to have standard, you're authorized to enter into this contract, nothing's preventing you from entering this contract, things that in general are going to be true, but make sure you watch out for the original requirement. Companies are going to include this, and particularly pay attention to whether or not you can use work that you've done previously. A lot of times a contract will specify this has to be wholly original work, not just something you pull out of your file, and that has to do with copyright and the company wanting to own it at the moment of creation. It also helps from the company's perspective avoid any claims about whether or not you've previously assigned it or done it for another company. So just pay attention to that, know what you can and can't use from your past portfolio. And then the other thing is which we've previously talked about, and whether to what extent you can use the work after its creation, including like if there's confidentiality provisions. So the license back and the confidentiality requirements are also going to be in the contract. From a business perspective, those are, especially the things we talk about with payment, amount of arts, deadlines, those are things that are commonly negotiated, sort of what we'd call the business terms. The thing is, as an attorney, I don't particularly care about. I'm told them, and then
we'll talk about them, and then like we can come to an agreement, and it'll be good. So those are like negotiable things, and totally negotiate them and make sure you get like stuff that makes sense and understand where the company's coming from and where you are.
The next thing I want to address are typically non-negotiable items, which I'm not your attorney, I'm not saying don't ask for these, but if I were advising a client and I was going to prioritize what to ask for versus some things you might want to let go so that you can focus on what you actually really want. Because if you come back with a whole bunch of changes, it's less like you're not going to get everything that you want, and there's a business reasons why you might want to have a smooth transaction. You don't want to be the contractor that the company is always dealing with. Just from a business perspective, it makes it less likely that they'd hire you in the future.
Like realistic, that also gets you more money. Like if you just come back and be like, okay, fine, I'll sign this contract or whatever, but you got to pay me some in advance, and then you got to pay me some later, and you got to pay me more money. That's easier. That if don't worry about the rest of the contract, just give me more money. That's more likely to get you more money, for example.
And more money in the future.
Yeah.
So the first thing that's probably
I was gonna say, as opposed, if you think about it from the business's point of view, if you do the other way, where you say, the amount of money you want to pay me is fine, but I have this giant laundry list of changes to your contract that you already paid an attorney to write for you, and now you have to spend even more money to run those changes by your attorney. Right. So like right off the gate, you're asking for all this special treatment that's costing them a lot of money to investigate. Yeah. Like that's not...
Either way, you're asking for more money from me, except like one way it's more annoying.
Yeah.
Like,
so some things that are sort of legal terms that are generally speaking not going to be negotiable are one, the choice of law and venue. That's going to be where the company is located, period, sort of end of story. It's really advantageous for the companies. Most companies have a policy that they won't even negotiate that. That way, whenever it comes up, we can say, we don't negotiate that, it is what it is. It's how you work with basically in any industry when you're talking about an independent contractor or an employee for that matter. Next is ownership of the artwork copyright. Unless it's a very, very specific instance, the company's going to have a policy on how they handle that, and all of it is going to be standard so that they don't have to track, if we have 120 independent contractors, which ones have which particular, like which ones we own versus which ones they own, and then we have to look back to the license to see what we're allowed to do. You can negotiate on the license back, but in general, most companies are going to have a policy about owning the copyright. 3, assignability. The company is going to want the flexibility to assign your contract in the case they're bought out. You won't be able to assign it though. The company is specifically hiring you based on your portfolio. If you have a business that has employees working for you, a lot of times the company will even specify which of the employees can work on it based on a portfolio and the particular style they're looking for at that product. The 4th thing that's probably not negotiable is the confidentiality of proprietary information. Because from the company's perspective, they don't necessarily know what information you'll even be given at the start of the contracting process, depending on exactly where the artwork goes, what you need to know for their plans, for how they're including it. It's going to be a long section. It is going to have, you can't disclose this. It'll have, though, that, confidential information doesn't include information that's publicly available through no fault of your own, that's released by Greater Than Games or released by another party. So it's not everything in the world, but it'll be a fairly long section. It'll have things like the company can bring a court action against you. It can apply for a preliminary injunction. It'll probably even specify the amount of the bond the company has to place with the court. All that means is that if you're disclosing something, usually you'll get a cease and desist letter first, though not necessarily. The company can always bring an action in court, and there are certain requirements they have to make, but assuming that it looks like they would win in the litigation itself, they can get a court order before the litigation goes through the whole process to have you take down whatever information you're disclosing or stop your disclosure.
That sounds like real bad. Like, oh my gosh, this company is telling me right in the contract they're going to sue me and they're going to get an injunction and it's going to be terrible. But on the other hand, there's a real simple way to avoid it, which is just be professional and don't disclose stuff before the company does.
And for the most part, you're not going to have access to much information. It's sort of a
hard to do,
rare.
yeah.
It's
like
a rare
if the company
situation.
says like, don't post this up because we're going to have it for a secret Kickstarter reward or whatever. Like it's bad. It's literally bad.
And generally, you should know. Like I try to always tell people, like, hey, I'm about to give you a bunch of information about this game that no one knows about. Please don't post this anywhere. Don't tell this to anybody. But here's what we're gonna do.
If there's any confusion about it, also just ask.
Yeah.
Just ask.
And honestly, like also from a business perspective, for me, like even if like an artist is like totally violating that and posting a bunch of secret stuff all the time, I'm definitely not going to sue them unless I send them a bunch of angry letters first, because it's way expensive to try to sue. So like you will get like piles of angry letters before anyone like even starts to think about doing legal things about you, almost certainly. So
Yeah. That being said, the contract is probably going to say they can go straight to court,
Right.
and this is what happens. The other thing that's probably not worth negotiating is the miscellaneous section at the end of the agreement. It's going to have things that, read it, try and understand it. That's probably the most legalese section of the whole contract, but it'll have things like a jury waiver. Really, that's not. It's going to make litigation less expensive, and juries are also unpredictable, which discourages settlements. That's the reason almost all contracts have a jury waiver. Usually your jurisdiction and venue in there, it'll have things like a waiver provision saying the company isn't waiving anything. If it decides not to comment on the fact that your drafts were 10 days late, it's not waiving its rights to require the final art to be by the final art deadline. Just things like that probably aren't worth negotiating, especially if you want other things and you want a smooth process, because most companies have a standard provision on that, and a lot of it is just sort of required by contracting law to sort of be the best, or a complete contract that's fully enforceable.
Yeah.
So now that we've sort of talked about the contract process, what you can expect to give up, what you should get in return, and things to be wary of, after you sign the contract, we go to the creation.
So then just real quick, talk about the process there and then do a Q&A. So like say we sign the contract, everything is great, going back and forth, like the process from like different people's perspectives, I guess. So from my perspective, what I want, so this is sort of like a life hack if you're an artist trying to run this as a business, send me an invoice. Send the company an invoice. And what I mean by an invoice, really what a company wants on an invoice is send them an email with a PDF on it that they can copy and paste out of that contains like the same payment terms as in the contract, like you have to pay me within 10 days, the amount of money that they owe you, what it's for, like I did the rough drafts or whatever, and then your full name and address of you or your company or whatever, because that makes it super easy for the company to have a record. If the company wants a record of who they're paying, you always want that as a company. And then also it makes all the information is right there that they want. So like it doesn't have to be particularly fancy. It's literally just something you make up. It's like just a form that like looks sort of official and it has that information on it. And that will make you look way more professional as a company and make the company really happy about you. So then they're like, oh, this guy can influence. That's good. Right. So that's like, it's a really easy thing to do that is like really, really nice.
You
So
can find like Google Doc.
you can Google that template and invoice to it or whatever, or like
what I
make a
do.
square.
Yeah.
Yeah, it's like really, it's very easy to do. But like it's a really easy thing to do that makes a big impact on doing it actually, from my perspective personally. And then and then basically from that perspective, like just invoice me when it's done and send the stuff to that whoever is managing your actual art.
When I started invoicing people, I started getting paid a lot faster.
Yes,
too.
that will also happen. You'll get paid way faster because people will, if you don't invoice them and it's just in the contract, like, and you just send them an email, like they will wait till the last minute, or they'll forget and wait till the last minute. You'll have to let them know, like that will happen. But if you invoice them like on those deadlines, they'll pay you fast. Usually the company doesn't not want to pay you. It's just that like they have a ton of independent contractors, and sometimes like things get missed or whatever.
Oh no, go ahead.
I was gonna say, make sure though, if you do have a form invoice, that you match when. So let's say you use a form and it says, and do within 10 days, and the contract actually says 20. Make sure you just check the contract so you're noting on your invoice that
the
if
payment.
the payment's due within 20 days on the contract, your invoice says 20 days.
Yeah, and it'll feel kind of tedious from your end because you're like, well, they sent me the contract and it's already in here, and now I'm repeating myself to some. Just remember, particularly depending on the size of that company, the person that you negotiated that contract with, and then the person you're going to work with for the art, and then the person getting the invoice are not always the same person.
Right.
So you're not repeating yourself. It's just that it's having to go through multiple things, and that's actually something really important when you're negotiating that contract and when you're done and you're like, okay, I'm ready to go. Make sure you know who you're supposed to be talking to next. Make sure you know who you're emailing, who your art director is, all of that information, because you just spent a couple weeks talking to one person and they are probably not going to be the person that you're going to in the next step. So make sure that you have all of that information up front.
Yeah. And communication with and asking questions is super, super key.
Yeah.
So ask so many questions about process and what you should be doing next and who you should be talking to and how stuff is going. If you're not asking so many questions that you feel like you're being annoying, you're probably not asking enough questions.
But do try and condense them down to one.
Right, yeah, exactly.
Yeah, no, I actually have, don't be afraid to ask questions.
Yeah.
When I started out, I was really worried that I might annoy a company into firing me from a job. It's a real fear that a lot of people have.
Yeah.
And then eventually you just start to realize no, it's good that you ask questions. They would much rather be communicating.
Right. The risk is way more on the other side, that you will lack of communicate your way into them not hiring you again. That's a way bigger risk.
I know from my perspective, when I am working with an artist and I'm going through the basics of, what are the pieces that I'm going to need and what do we need it to look like and all of the details of those pieces. If you don't understand something, ask me, because I'd rather go through that in detail before you've put in a week's worth of work and now we have to start over because you didn't understand what we actually needed or I didn't communicate correctly what we needed. So please don't be afraid to ever ask a question or say you sent me this really great description, but that makes no sense to me. Can you send me a reference image? Can you send me something other than that so that we can actually start off on the right page? That's super important. Same thing with deadlines. I know we kind of keep using that word and we keep saying it a lot, but it is really, really important. If we put deadlines in that contract because we know what we need to do on our end, but if something happens, we're human and we understand that life happens. If you're hey, this piece of work that we thought would take 3 days is actually way more complicated than we thought it was. Is there something that we can work out? Can we negotiate this? Or, I don't know, a family member's in the hospital and you need 2 days to go, be a person. That's fine. Just let us know ahead of time and just please, 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 please don't ignore emails from your art director or your creative director going, hey, where's this piece? Hey, hi, are you still there? Because then we start stressing out and then it's is this person going to deliver on time? I don't know what to do. I can plan for it if I know.
Yeah, communicating delays and problems is great, and actually, you can still get hired again after that. Yeah. Ignoring them because you're feel bad that it's late or whatever, and you're ignoring it and hoping it goes away. That's what'll make it so that no one wants to.
Nolan and I have done that a bunch, where we've negotiated timelines.
There's been one situation when I started working in the board game industry. I was I'm never going to miss a deadline, and there's been one time where I missed a deadline, and a month before that, I emailed Paul. I said, hey Paul, I'm going to miss this deadline. If you want to terminate the contract and hire somebody else, that's fine. I just want to let you know I'm not going to be able to meet this deadline that we originally agreed on. And Paul got back to me. He's it'll probably just be faster it'll be better and faster if you just delay it and push the deadline out. So just be communicative about it.
Yeah.
I mean, don't do it all the time, obviously, because we are depending on you to give us a deliverable at a certain time so that we can then turn around and make the game and get it out to everybody that's depending on us. But every once in a while, we understand it's going to happen.
Be upfront about it.
Yeah, absolutely.
Any other particular things anyone wants to say before Q&A? Or?
No, that's all right.
All right.
I covered a lot, so.
Who's got? And what questions do people have, if any? Things you'd like us to talk more about, that kind of stuff. Yeah.
It sounds like communication and working with the artists and getting a relationship going is incredibly important. How is it not easier to just have them on staff?
So there's a few different reasons for that. So having an artist on staff is certainly very nice. So Adam, my business partner Adam over there, who started the company together, he's also senior illustrator and spends a huge amount of time illustrating massive numbers of comic book pages. That's super cool that he's just right there and we can talk about stuff and work that into things like that. But unless you're in a situation as a company where you have really genuinely full-time work for that artist, it's not worth it, right? Because specifically we happen to be in a situation where we have full-time work for people drawing comic book characters, but that's really rare for a board game company. Usually board game companies are doing a ton of different games in different styles and want to have different artists be doing it. So that's one thing. And then on top of that, often you're going to have a turnaround time on games that is so fast that one artist can't do it. So Adam also happens to be very fast at drawing comic book characters. That's great, right? It's not, but often, like, say you have a game where you need these like elaborate oil painting arts and you need tons of them. There's no way you can have one artist do all of them. So even though like I could pay one artist, like, okay, this one staff artist is like working full time on this game for 4 years drawing these oil paintings, that it doesn't work from a business perspective. What we really need instead is 10 artists all doing oil paintings simultaneously to get us the art at that time. So does that make sense, right? And then on top of that, from just a business perspective for costs, like it is much more expensive to have an employee and like commit to having that employee and pay them all the time and pay W-2 wages and pay the taxes and stuff on top of there than it is to have an independent contractor. So there comes a point where it's worth it. But like even for like Nolan does a lot of work for us, and like maybe if we started doing a lot of games at Nolan, but it's like it's a ways off, right? It's like before we'd have that much work for.
To another point about communicating, from your end of things as an artist, please let your art director know what medium you're using. Are you using traditional medium? Are you doing watercolor? Are you doing oil? Or are you doing digital painting? Because that lets us know how much more involved we need to be in the earlier steps of the process. So are we going to go through, so usually when I do it, we start with some sort of concept sketches, blocking out basic composition, things like that. Then we'll go to, blocking in colors, and then we'll start going into more details. And this kind of ties into the idea of deadlines and how long pieces are going to take. Let me know beforehand if you're doing some sort of watercolor or something that once we get to that stage, we can't, it's not Photoshop, I can't edit undo this thing, we'd have to rework a bunch of the painting. That's really, really important to let them know up front. So please let us know what your medium is.
Any other? Yeah, back there.
If I agree to pay it after publication, at what point do the rights revert back to me for those accounts? Or do they not?
They don't necessarily. So if you said the compensation is payment on publication, we're talking about a situation where it's not published. They wouldn't clearly ever revert back to you. You'd have an argument that you could bring that there wasn't adequate compensation, but that's sort of it's a common law argument. It's going to vary state by state, and without litigation and a court order, it's a little nebulous.
So one of my dreams for this panel, by the way, is to exhort you all never to sign a contract like that. Please don't. So like the part of me that is like, okay, I'm in business, and they're like, what if I were a supervillain? Oh, I would want everyone to sign contracts like that. That would be great. I could be a supervillain better as like a supervillain business guy. But like, don't do that. Like if someone's trying to do that, they're doing like a supervillain business guy thing. Because they can just like never publish it. Or like, you can just get tons of work for free out of people. Like, just tell people, like, and it's very, very reasonable to expect to get paid for work that you do for a company, right? Mm-hmm. So like for us, like all of our contracts, like I will always pay an artist for all of the work that they do for something, even if it's a game that winds up not being published, right? So like we always will get a bunch of art for a game before we take it to Kickstarter. Just as a matter of course, you have to, right? In order for us to possibly fund a Kickstarter. But like, we'll always pay for that art like as soon as it's delivered and things like that. It's not contingent on publication. And as Kickstarter gets more and more prevalent, like there's a bunch of smaller companies that like realize like, ooh, I could do this trick. Where like if the Kickstarter isn't fun, I just don't pay the artist. That's great. But like, don't sign that. Don't do it. That would be my recommendation as a business guy.
And one thing to think about when you're contracting is who should bear the risk of loss. And for producing the game, it should be the company. And by making your payment contingent on whether or not they produce the game, they're just trying to shift that risk of loss onto the artist, which in an equal bargaining world would be an unfair shift of the risk.
Right.
Are you working on something like that right now?
I have done it in the past. I just want to know when those rights come back.
Gotcha.
But if the one thing to mention, so it's not clear. However, if they never produce the game and they're not using your artwork right now, send them an email and ask. If
they
you
might
have
just
that,
give it to
they
you.
might just give it to you, and even just an email with their name and the company's name on it, saying no, you own this. We recognize we're not going to pay you, is better than nothing.
Yeah.
I mean, ideally there'd be like a bill of sale and assignment or something, but even just an email with their name, like their position at the company and the company's name is better than nothing.
Yeah, just a general business question. When you're working, do you typically have a preference if you're working with individual freelancer or like a freelance studio, for example?
Right. So I don't specifically necessarily, from my perspective. So from my perspective, solely as Greater Than Games, it is a little bit easier to just work directly with individuals. But like the amount that it's easier is barely. And from the perspective of someone that like wants to help you all out, like at whatever point it becomes business correct for you to create an entity, a legal entity around your thing, whatever your business decision, what your call is there, totally do it. Like it's not going to stop a company from wanting to do it.
Were you talking about like joining a studio, like having or
I mean, yeah, there are smaller studios
Yeah.
that are just freelance concept artists, for
gotcha?
example.
Yep.
I don't care, personally.
There are some board game companies that work mostly with studios. Like there are some pretty infamous
Yeah.
studios that do a lot of the artwork in the board game industry, but
Yeah.
most, from my experience, mostly individuals.
Right.
Yeah.
And the one thing you talked about if you're forming an entity, the one thing to remember when you're forming an entity is maintain its organization correctly. It's not just a matter of filing one piece of paper with your Secretary of State once and then ignoring the fact that you made an entity. Some states require you to have annual filing fees and annual reports. If they're hiring the company's attorney is going to look you up and see whether or not you're in good standing. It's significant because you're going to make reps and warranties in your contract that you are in good standing and you have the authority. If you're not in good standing, you're also losing the corporate protection that you're trying to make. If you're relatively new and unestablished and your company basically has essentially no assets, its sole asset is it's a services company, don't be surprised if especially in the beginning of the relationship the company requires both you and your entity to be on the contract, because things like your representations and warranties and your indemnification, which is basically saying you're going to pay back the company for any damages it suffers because of your breach of these representations and warranties, is only so good as the contracting entity has assets. So if you have a no asset entity, the company is going to know this, and so they might require your individual signature, especially in the early stages before you sort of have a reputation and have a bunch of incoming receivables.
So something else to follow up on yours, actually. I would say an exception. So if you're super self-aware and you know about yourself, you're like, look, I'm good at drawing. I know that I really cannot, I'm not going to do these responsible business guy things that you're saying, right? I'm just seriously not going to do that. And you know yourself that about yourself, and you're like, I can draw stuff well. I'm not going to do this shit right. I'm going to mess things up. I'm going to frustrate the company by trying to do the business things. That's a situation where and then it might totally be the right choice for you business-wise to join another, a larger entity where someone else is going to handle that. The invoicing and the making sure the contracts are right and the communicating back and forth, and you just gotta sit there and draw stuff, then that makes a lot of sense, actually. That would be a good reason to do that.
Mm-hmm. Because the other thing that's going to be important and the company might want to see is that you've actually assigned your work into the company that you've created. Because if you're not an employee, you're not paying yourself wages, you're just the owner, you're going to have your bill of sale and assignment set up to make sure that your entity is actually owning the art and saying it's transferring. If you have independent contractors, the company is going to want to see your independent contractor agreements going down to make sure that it has the work for hire and assignment
to make sure that the copyright ultimately gets to us.
So goes this. So there's a lot of paperwork that you might be asked for if you have an entity to make, because the company, especially if you're a large component of a game, might want to go all the way down to do its due diligence just to make sure it's correctly that everyone owns what they think they own.
So this is a really common question, is should I incorporate, should I form an LLC, that sort of thing. And there's lots of different answers to this question. But from my experience, starting out, I've been working in the industry for 3 years now, and I had no need to incorporate for any reason. You're not making crazy amounts of money, especially starting out in the industry. So there's that's you don't have a ton to protect. So incorporating isn't always necessary in the beginning. I'm just now starting that process because I'm at a point where I feel okay, maybe I do need to start protecting my brand, protecting this, that.
And as a business guy, what I would think about is be that kind of stuff. Also, as you're doing more and it's becoming, this is my full-time compensation, and then so that makes sense to do it. Also, if you're going to a bunch of shows and you're selling stuff and you need to register for sales tax, and then maybe you have a booth at a bunch of conventions and the conventions want you to get insurance and all this kind of stuff. then okay, now I'm doing all this other stuff, and I want a legal entity between me and like Gen Con, or between me and the state of Indiana or whatever.
That's,
Yeah, and I mean, in general, it's recommended, but only if you do all of the backup work and keep it organized.
Just another question too, with just legal advice and in general, who do we? Is there like specific lawyers that we can target or speak to? I mean, I know like we have to ask someone in our state, but is there like a title of like a specific lawyer?
In general, so you don't actually have to ask anyone in your state. So the rules regarding what attorneys can give advice where are a little bit weird. I can only give legal advice with limited exceptions in states I'm licensed in, but if I'm in Missouri or Illinois, I can tell you the law wherever. It's kind of odd. So any attorney would work. In general, you're going to want to look for just a general business law firm. When choosing attorneys, some things to keep in mind to keep your costs down are in general smaller law firms that still have a business practice, and especially that are focused, that don't necessarily also do, depending on the size of the municipality you're in. In general, if you're in a small town, you're going to have more just general practitioners. They do everything. But in general, smaller firms are going to have lower rates, and you're looking for firms that have business services, business formation, startup, contracting, probably not like a family law firm or a law firm that just does trusts, wills, and estates. It's not necessarily going to be right in their wheelhouse, especially once you're talking about the IP. But even though we're talking about copyright concepts and that sort of thing, you're not going to need, in particular, an IP specialist necessarily, just attorneys and law firms that specialize in contracts and do business law.
An organization that some of you may have heard of that I would want to mention, especially if you're really pretty cash strapped, but you do want to try to get some legal advice, is the Volunteer Lawyers and Accountants for the Arts. There's chapters for that in most states, I think, and it's what it sounds like. It's volunteer lawyers and accountants who help artists in all kinds of different media and industries, and so they are not necessarily going to be able to give you the sort of full service legal experience. They are volunteers, but this sort of pretty simple stuff like, hey, can you look at this contract for me, kind of things, then they quite possibly can help you out. So just look for the regional group of that in your state.
Any other questions?
When an artist wants to negotiate an aspect of the contract, what's the best way to approach that to make it as beneficial as possible?
Yeah. So for me, what I just want is basically like so you look at the contract, I'll send you a draft, and then just send me an email back. This is from my perspective. If it's a small number of simple stuff, send me an email back and be like, oh, I'm curious about this. I've got this concern about this, and like I want to change something about this, and just send me back like a bulleted point list. Ideally, either like just bullet points of a few different points. If you're referencing specific sections of the contract, put that in there, like in section Q27 or whatever. Like whatever, like here's a thing that is concerning. So if it's just a small number of things and they're mostly business questions, then the two of us will just talk, right? So then you would be like, okay, well, you're like, well, I need to, like, usually we'll ask up front, like, how much do you charge for this? And then if it's like, wow, that's outside of our budget, we'll go, wow, that's outside of our budget, but we really like your art, like, can you tell us why? Is there anything we can do to change it? Either are we misunderstanding what you think you want, what we think you want, or is there something that we just don't realize, like, this is really time consuming, guys? And then you can maybe convince me it's really time consuming, and then like, no, that's how much it has to cost. Okay, nope, you explained it, right? Or like, oh, I thought you wanted like these 27 complicated things, and I was just thinking I wanted a simple thing, and then we can get on the same page, or whatever, right?
So like start to finish, and I can only speak to how we do this, but initially when we find someone that we want to work with, one of the very first emails we send out is going to be, here's a really basic, rough foundational idea of what we're looking for from you. What kind of compensation do you think this would be? Because we have a number in our brain of what we can do to make this game work. And so then we're going to kind of open up the conversation to you first and say, hey, how much time do you think this would take? How much money do you think this would cost? Things like that. And then you've already kind of opened up that negotiation right from the get-go.
Right, and then before we even get
right, and then we can go back and say like, ooh, okay, that doesn't work, but what if we bulk price it and we give you a couple more pieces in this area so that then we can split off some of this more expensive stuff or things like that. You've already initiated that negotiation at that point. So don't feel like, oh no, this is the scary part where I have to like go back and forth and tell them no. we're already like ready
Right, yeah.
to do that. So,
Right, yeah.
so don't be afraid of it.
And often by the time we get to the contract, I'm like, okay, now we've kind of agreed on a price. And usually, when you say like, what I'll do for a game is I'll know like roughly the art budget for this game should be somewhere around here. But then like it's going to be a bunch of different artists doing different things, and I don't know how long it takes to art. So like, what we want to do is figure out and we might like Jen might have a little bit better idea of what things are going to be expensive and what things aren't. But in general, we're not going to really know. So what we want to do is send all the different artists like, here's what we kind of want you to do. Here's what we kind of want you to do, and have everyone tell us how much it'll cost for them to do it, right? And then we can be like, oh, okay, yeah, no, this is the expensive part. I see that now because it's like really fiddly or hard to draw or whatever, and these things are a little bit simpler because there's some really simple little stuff, and then okay, now we can assemble a budget. And if we got to be like, oh yeah, it's going to be way too expensive to do this kind of stuff here, we're going to alter the game design a little bit to save money over there, or negotiate back and forth. So that's why we always like ask for the prices up front and stuff.
Like, because generally the creative director or the art director or whoever is probably going to be working with the person that's negotiating, or maybe the person you're negotiating with. So, like for me, I have a fine arts degree, so I've done some of this stuff. I've done Blender, or I've done Photoshop, or I've done all these things that like I understand how long it takes to do this. So when you present me a number, I can be like, yeah, that seems reasonable, or okay, that seems like it's going to be a little higher or take a little longer than we think it should. Let's go back and negotiate and see where in the process I'm misunderstanding what you're thinking.
Yeah. So we've got time for one more quick question in here, but then like I at least will go out there. Some of us will be out in the hall and we can ask after they kick us out of the room. So yeah.
This is something I don't see very many people talk about. But like, what are the actual numbers that is reasonable for artists to say? Like, well, what would you go? I cannot work with this artist because they're asking for too much, or I can take advantage of this artist because they quoted me something that's real cheap for what they're.
The trouble is, like, it varies so much depending on exactly what you're talking about art-wise. So like, if I were in your situation trying to do it, because I realize this is a hard question, and it's something that, like, as an artist, like, how do you price it?
We can do a whole panel on this question.
Yeah, exactly, right. And like, Nolan might be able to speak to this a little bit more, but from a business guy perspective, what I would do is think like roughly, okay, like, what is my time worth hourly? Right? And then like, how many hours will it take to do this? And just quote them that. And if like they can't meet the hourly rate that you need to get in order to make it worth your time to do it, then like, well, it's a good thing you didn't, like, they can't pay you. It's not worth it. Like, there's not going to get any money there. So they should say no. You want them to say no, right? And then if you're like, okay, this is an hourly rate. I'm getting paid my hourly rate roughly to do a thing. Then like, great, you made the money hourly that you could make it. So like, and then you figure that out over time, kind of.
And I think I could be wrong here, but feel free to ask that question to other artists too.
Yeah.
That's really going to be the best way you can get a kind of a good idea, because I know just based on working with artists kind of roughly what I expect to see when I ask for like, I want an isolated full body character art. I kind of roughly know what I'm expecting to see back from someone. But like, if you're really not sure, like, talk to other people in the business, talk to the art directors, that kind of thing. So
yeah, you'll get used to it, and you'll get, like, Jen just gave that description and a number flashed in my head.
Yeah.
It's like something as you do more of.
Because no one knows how long it takes them to draw that. Yeah, Adam.
If I can add to that,
Yeah.
actually, if you were, it kind of depends on how much you want the job also.
Yeah.
Like if it's more important to you to get some work than none work at a higher rate, ask them what they're willing to pay.
Yeah,
Also.
and that's also.
Ask companies what the rate they're looking for is if they don't respond well to your initial offer.
Yeah, and ask them for the specific thing. They've told you like, oh, we want these specific things. You'd be like, all right, like, how much are you can pay for that? And like, then they can get back to them, right? And then also, like I said, like when I think about translating it all into hourly rate. So the company will ask for a certain number of arts, translate that internally into hourly rate, and then come back at the price. Your hourly rate will go up over time as you get more experienced and less desperate for work. So honestly, right? So if you're starting out as a freelancer on the side, you're like, I need to get paid for. I got to pay for my work, and I can do it for exposure or something. But like, your hourly rate will be lower, which makes sense from a business perspective. You've got less experience, less reputation in the market, less guarantee you're going to be good. But as you build up and do that for more companies and do a good job, you're going to be in more demand, right? And then your hourly rate will go up, which means that your prices will go up and you'll be able to.
As when you start out, the value that you're getting to adding to your portfolio is sort of compensating for your lower.
And then you might really want it, like Adam said. You might really need it.
Is it better to overquote or underquote?
It's better to overquote.
Overquote?
Yeah. Everybody's afraid of it. Everybody's because they're like, oh, if they don't like this quote, then they're never going to talk to me again. No, overquote. And so like I have a range. I always overquote, and I have a minimum that as long as I can hit that minimum, I will accept that job. And that minimum, and there's so like an hourly rate is great. I also do a daily rate, and that's how I judge a lot of mine. And I can talk more about it after this, since we're running out of time. If anybody wants.
Okay, well, but we can keep talking. We can keep conversing in the hallway.
Awesome. Thank you guys so much for coming.